The signature pages in my finalized case bundles were blank. I discovered this at 11:47 p.m. on a Tuesday, 3 hours before our appellate brief was due to the Colorado Court of Appeals. My name is Tate Carrington, and at 38, I've spent the last 6 years as legal technologist at our startup legal hub in Boulder, specializing in complex civil litigation and appeals technology integration. The discovery happened by accident. I was running final quality checks on the Morrison Construction defect appeal when I noticed the electronic signature verification failed on page 47. The document showed my digital signature metadata, but the actual signature field displayed nothing but white space. My hands went cold. I pulled up the case management system and ran diagnostics on every brief filed in the past month. The pattern emerged quickly. 17 separate case bundles, all major appeals, all missing critical signature pages that should have contained my authorization. The system logs showed the documents as "and filed," but the signature verification protocols revealed empty fields where my approval should have been. Someone had systematically inserted blank signature pages into finalized legal documents. The metadata timestamps told a disturbing story. Each alteration occurred between 2 o'clock and 4 a.m. when our office systems ran automated backups. The access logs showed legitimate user credentials, but the IP addresses traced to our internal network. This wasn't external hacking. Someone with administrative privileges was manipulating our most sensitive case files from inside the firm. I cross-referenced the affected cases with our client billing records. Every altered document corresponded to high-value appeals with retainers exceeding $50,000. The Morrison case alone represented a $200,000 engagement. My phone buzzed with an encrypted message from our case management system. Signature verification anomaly detected. Administrative review required. The timestamp showed the alert had been generated 6 weeks ago. I had never received it. Someone had been intercepting my security notifications while systematically compromising our most critical legal filings. The scope of potential malpractice exposure made my stomach turn. If opposing counsel discovered unsigned documents in our appellate submissions, every case could face dismissal for procedural violations. I pulled up the user access logs for our document management system. The entry showed my credentials being used to authorize the blank signature insertions, but I had been in depositions during every timestamp. Someone was using my administrative access to sabotage our own cases while making it appear I was responsible. The office felt different now, shadows longer in the emergency lighting. Every colleague became a potential suspect. Every system alert could be another manipulation. Trust, the foundation of legal practice, had evaporated in the span of an hour. I needed to understand who had access to my credentials and why they were systematically destroying our appellate practice from within. The next security alert arrived as I sat staring at the document integrity breach detected in Carrington case files. Immediate administrative action required. This time, I knew I wasn't supposed to see it. The betrayal had roots stretching back 18 months, to when I first hired Damon Yorkshire as our appellate strategy consultant. I was 38 then, building our Boulder practice into something that mattered. The startup legal hub downtown buzzed with innovation, and I wanted our firm positioned at the center of Colorado's emerging tech litigation landscape. Damon came with stellar credentials from Denver's appellate courts and a reputation for turning impossible cases into victories. He impressed me immediately. Sharp legal mind, meticulous attention to procedural details, and an understanding of appellate strategy that elevated our entire practice. Within 6 months, I had given him administrative access to our case management systems. He needed it to coordinate complex filings across multiple jurisdictions. They allowed my sibling to intern under their wing during law school, and Damon mentored her through her first appellate brief. His dedication to developing young talent sealed my trust completely. The warning signs started small. Client complaints about missing signature pages in settlement agreements. Opposing counsel questioning the validity of our court filings. I attributed these issues to growing pains as we expanded our caseload. Then Irene Blackwood joined our firm as a junior associate, Fresh from the University of Colorado Law, she brought a digital native's perspective to our document management protocols. She noticed discrepancies I had missed. "Tate, these timestamps don't match," she said, pointing to her screen during a case review meeting. "The Morrison brief shows final signatures at 3:47 a.m., but our security logs show the building was empty." I dismissed her concerns initially. Automated systems often generated confusing timestamps. But Irene persisted, documenting anomalies across multiple cases. Her methodical approach reminded me why I had hired her. The breakthrough came when she discovered the signature page manipulation. Using forensic document analysis software, she proved that blank signature pages had been inserted into finalized bundles after my electronic approval. The technique was sophisticated, requiring administrative access and detailed knowledge of our filing procedures. "Someone's been doing this for months," Irene explained, her laptop displaying side-by-side document comparisons. "They wait until you approve the final bundle, then swap in blank signature pages before court submission." The scope became clear as we analyzed affected cases. 17 major appeals over 14 months, combined retainer value exceeding $1.2 million. Each case now faced potential dismissal for procedural violations, exposing our firm to massive malpractice liability. I confronted them methodically. The user access logs showed my credentials authorizing every manipulation, but security camera footage proved I was elsewhere during each incident. Someone with my administrative passwords was systematically sabotaging our practice while ensuring I would bear responsibility. The digital forensics revealed the truth I had been avoiding. Only 3 people possessed the necessary access levels: myself, our IT administrator, and Damon Yorkshire. Our IT administrator, Irene Thornfield, had been on maternity leave during half the incidents. The log showed no remote access from her home network. That left one possibility I didn't want to accept. Damon had been using my credentials to insert blank signature pages into our most critical appellate filings. His access to my passwords came through the administrative privileges I had granted him 18 months earlier. Trust had become the weapon used against me. The motive remained unclear until Irene discovered the financial component. Cross-referencing our billing records with Damon's consultant payments revealed a pattern. He received performance bonuses tied to successful case outcomes. By sabotaging cases through unsigned documents, he could claim the failures resulted from my negligence while positioning himself as the solution. Several clients had already approached him about handling their appeals independently after losing confidence in our firm's competence. He was systematically destroying my reputation to steal my client base. The query was overwhelming, but I needed absolute certainty before taking action. Irene helped me set up monitoring software to track all administrative access in real time. We waited. 3 days later, our system captured Damon accessing my credentials at 11:23 p.m. to modify the Henderson case filing. Security cameras showed him alone in the office, using his laptop to insert blank signature pages into documents I had approved that afternoon. We had him. The betrayal was complete, documented, and devastating. 18 months of systematic sabotage designed to destroy my practice while enriching his own consulting business. The man I had trusted with our most sensitive cases had been methodically dismantling everything I had built. But now I had proof, and Damon Yorkshire had no idea his carefully constructed deception was about to collapse. Monday morning arrived with the weight of absolute certainty. I had spent the weekend reviewing every piece with Irene, building an airtight case against Damon Yorkshire. The documentation was irrefutable. 18 months of systematic sabotage captured in digital timestamps, security footage, and financial records. I called an emergency partner meeting for 9 a.m. Our managing partner, Irene Blackwood, listened in silence as I presented the cell. The room grew colder with each revelation. Billing discrepancies totaling $847,000 in lost revenue. 12 major cases compromised through unsigned documents. Client complaints that should have triggered immediate investigation. "How long have you known?" Blackwood asked. "Confirmed? 3 days. Suspected?" 2 weeks, she studied the security footage showing Damon at his laptop, inserting blank pages into the Henderson filing. "This is criminal fraud. We need to involve the authorities immediately." The confrontation came at 10:15 a.m. I called Damon into the conference room where Blackwood and I waited with printed folders. His confident stride faltered when he saw our expressions. "We need to discuss some irregularities in our case management system," I began. Damon settled into his chair, maintaining eye contact. "What kind of irregularities?" I slid the first document across the table. Security logs showing his unauthorized access to my credentials. "These logs indicate someone has been using my administrative privileges without authorization." His face remained neutral, but his hands stiffened. "System glitches happen. IT departments make mistakes." Irene Thornfield confirmed these aren't glitches. I placed the financial analysis in front of him. "Your consultant bonuses correlate directly with cases that failed due to unsigned documents." The silence stretched for 30 seconds. Damon's composure began cracking around the edges. "You're suggesting I sabotaged cases for money?" "I'm stating it as fact." The security footage came next. "This shows you accessing my credentials last Thursday at 11:23 p.m. to modify the Henderson filing." Damon watched himself on screen, inserting blank signature pages into documents I had approved hours earlier. His shoulders sagged slightly. "The is comprehensive," Blackwood interjected. 18 months of systematic fraud. We're terminating your consulting agreement immediately and referring this matter to the Colorado Bar Association." "You can't prove intent," Damon said quietly. I opened the final folder. "Your email communications with 3 former clients discuss taking over their appeals after our firm's, quote, repeated failures. You were actively soliciting business based on problems you created." The fight went out of him completely. "I never meant for it to go this far." "You meant every bit of it." I kept my voice level. "You calculated the financial impact. You targeted our most vulnerable cases. You destroyed client relationships systematically." Blackwood stood. "Security will escort you out. All firm property must be returned immediately. Any attempt to contact our clients will result in additional legal action." By noon, Damon Yorkshire was gone. His office cleared. Access revoked. Consulting agreement terminated. But the damage required extensive repair work. The Colorado Bar Association assigned investigator Ian Parker from the Trust Account Oversight Committee to review our case. Parker's economic risk response team conducted a thorough audit of our financial records and client communications. "The fraud appears contained to one individual," Parker concluded after a week-long investigation. "Your firm's response was appropriate and timely. However, affected clients must be notified and given options for case remediation." We spent the next month rebuilding. 12 clients required new filings with properly signed documents. Our malpractice insurance covered most financial damages, but reputation repair took longer. The Bar Association filed formal charges against Damon for professional misconduct, fraud, and breach of fiduciary duty. Criminal charges followed when the district attorney's office reviewed the TWI. The systematic nature of his deception elevated the case to felony fraud. 3 months later, Damon pled guilty to computer fraud and theft. The court sentenced him to 18 months in prison and ordered $847,000 in restitution. The Bar Association imposed permanent disbarment. But justice extended beyond punishment. Other firms came with similar experiences after news of Damon's conviction spread. His pattern of consultant fraud had affected multiple practices across Colorado. I testified at 2 additional criminal trials, helping prosecutors build cases against Damon for fraud at other firms. The we had gathered became the template for investigating consultant misconduct throughout the legal community. Irene Thornfield returned from maternity leave to find our security systems completely overhauled. We implemented multi-factor authentication, regular access audits, and real-time monitoring of all administrative functions. "Trust but verify," she said, reviewing the new protocols. "Just verify," I replied. The Henderson case, despite the sabotage, eventually succeeded on appeal. Our client recovered $2.3 million in damages, validating the strength of our original legal strategy. Other compromised cases were refiled and won, restoring client confidence in our competence. By winter, our practice had not only recovered but grown stronger. The experience had forced us to examine every aspect of our operations, eliminating vulnerabilities we hadn't known existed. The legal community took notice. Bar associations across multiple states began requiring enhanced oversight of consultant relationships and administrative access controls. Our case became a cautionary tale taught in legal ethics courses. But the personal cost remained. Trust, once broken so completely, required careful reconstruction. Every new consultant underwent extensive background checks. Every administrative privilege was granted with specific limitations and regular review. The betrayal had taught me that competence and character were separate qualities, and that professional relationships required the same careful documentation as legal cases. 18 months later, I stood in the conference room of our new office in downtown Denver, reviewing partnership agreements with 3 former colleagues who had joined me in this venture. The view from the 32nd floor stretched across the Front Range, a reminder of how far we had traveled from those dark months in Boulder. Our practice specialized in legal malpractice defense and professional responsibility cases, work that felt both familiar and redemptive. "Tate, the Morrison hearing is scheduled for next week," Irene Yorkshire said, entering with a stack of case files. She had followed me from the Boulder firm, bringing her meticulous attention to detail and hard-earned skepticism about administrative oversight. The Morrison case involved allegations of judicial misconduct in a family court proceeding. Complex ethical questions, multiple jurisdictions, and a client whose reputation hung in the balance. Exactly the kind of challenge that had drawn me to law originally. I co-founded a firm defending judicial misconduct allegations, finding purpose in protecting legal professionals who faced unfair accusations while holding accountable those who truly violated their duties. Our security protocols remained stringent. Every consultant underwent comprehensive background verification. Administrative access required dual authorization. Case management systems logged every action with timestamp verification. The paranoia had evolved into prudence. Damon Yorkshire's conviction had rippled through the legal community, prompting reforms in consultant oversight and administrative controls. 3 other firms had discovered similar fraud patterns, leading to additional prosecutions and enhanced industry standards. The Trust Account Oversight Committee had commended our cooperation and used our investigation methods as a model for other cases. Ian Parker, the economic risk response investigator, occasionally consulted with us on complex fraud cases. My phone buzzed with a text from a potential client, another attorney facing ethics charges that appeared questionable. The work continued, each case a chance to restore faith in legal institutions while maintaining vigilance against those who would exploit them. The Henderson appeal had ultimately succeeded, recovering full damages for our client despite the sabotage. Other compromised cases had been refiled and won, proving that good legal work could survive even deliberate interference. But the deeper lesson remained. Trust required constant verification, and professional relationships demanded the same careful documentation as any legal proceeding. The afternoon sun cast long shadows across the conference table, where partnership documents awaited signatures. 3 attorneys who had chosen to build something new, rather than simply repair what had been broken. Outside, Denver's legal district hummed with activity. Lawyers hurrying between courthouses, clients seeking justice, the endless cycle of legal work that formed the backbone of civil society. I signed the partnership agreement with steady hands, thinking of blank signature pages and forged documents of betrayal discovered and justice served. The experience had changed my practice, but not my faith in the law itself. The work continued. The vigilance remained. The trust, carefully rebuilt, felt stronger for having been tested. It was finally over, and the silence felt earned.